make my afternoon. When you start, I will start shivering because I know
Your
the
ladyship,
heat that is going to emanate from.
for me, I got an instant headache
Yes.
just listening to my colleague.
Yes.
I can't believe what I heard. Let me start with the first charge sheet filed in this case.
Before you go to the first charge sheet,
Yes.
Kamugo,
Yes.
there are certain things he has addressed as having served. Perhaps you could start by
Start by
confirming or denying.
I rejected service at about 1:30, about 1:15 today. I understand somebody called Inspector Otieno came to my office to serve me with some statements, and I said to serve me 45 minutes before a ruling is to preempt what might be coming in the ruling. So I said serve in court depending on what the ruling on directions will be. It is very possible, Your Ladyship, maybe I was being too hopeful, that you might have made an order that what is not served stays with the prosecution and will proceed on what is served, given the time it has taken. So it was based on legal considerations. Now that you have ruled in the manner that you have ruled, Your Ladyship, they are at liberty to serve us. We shall look at what they have.
All right, proceed.
On 12th September 2019, one Nicholas K. Mutuku, OGW, Deputy Director of Public Prosecutions, signed a charge sheet for the offense of murder against the first accused. Very senior colleague of mine. When I say colleague, I mean as an advocate. I have also worked with him when I was deputy. At the back of that charge sheet, Mr. Mutuku indicated copies of the evidence which the prosecution intends to adduce at your trial are attached here. Copies of documentary exhibits may be inspected by yourself if released on bail or by your advocate on prior arrangements with the investigating officer, Mr. Maxwell Otieno, Mr. Inspector Clement Moore. Your Ladyship, Mr. Nicholas Mutuku lied on the 12th of September 2019 to this court. Why should I believe him today? He lied. Why should I believe him? Why should the court believe him today? Over 6 months after the first accused was charged, Mr. Mutuku now wants 2 more months, making a total of 10 months from the date of his first lie. That's now when he says he will be able to avail to us the evidence upon which he relies to prosecute the first accused. It is a great shame for the office of the DPP. But I go on to say, and I am glad today, and I'm glad for your directions, Your Ladyship, that you have finally forced the DPP to indicate who the prosecutors in this case will be. Why? Because we have seen exactly what the court has seen. Again, of different prosecutors coming to court every day, which prevents accountability for any statement made. We don't know who we are up against. Each prosecutor says, it wasn't me. But today, my good friend Mutuku has said, it shall be him and Miss Gishui. Again, just on that point, the last time we were here, Ms. Gishui gave us a list of 5, including the 2 of them. Why did she have to tell us something that was not true? What will the next prosecutor come and tell us? Mr. Mutuku was not serious. But it is fortunate that finally we know, if we take them to their word in the light of their ruling. And I would like to take this early opportunity to say, and I have indicated it several times before, including in the application dated 2nd March 2020, filed on that day, and I think it's dated 27th February 2020, but it is filed 2nd March. Your Ladyship, at paragraph on page 6, grounds upon which we have based that particular application on.
You are arguing the application?
No, I'm not arguing it. I am touching on the prosecuting counsel. At the last paragraph, we have indicated, in addition, Ms. Catherine Mwaniki, SADPP, Mr. Nicholas Mutuku, DPP, the Deputy DPP, DDPP, and Ms. Gakui, prosecuting counsel, were present at the controversial recovery of the body of the deceased, which makes them witnesses and therefore incapable of prosecuting this case. So I'm giving notice here now that we will be objecting to Mr. Nicholas Mutuku and Ms. Ishui prosecuting the cases because they are witnesses. In fact, I want to look at my bundle quickly to see whether they have recorded their statements. The centerpiece of this case is where the body of the deceased was found. And the 3 prosecutors were there at the alleged recovery, giving directions to the police. They are material witnesses. Why do I say they are material witness? It is the defense case that the body was planted there. So whoever says it was found there must call all witnesses who were present during the alleged recovery. Your Ladyship, the last mention of this case, Ms. Kishui said she needs 2 weeks. 1 week ago, it would have been expected that Mr. Mutuku would say, we have provided so many other statements, we stick to our request for 2 weeks. In 1 week we shall provide everything. Your Ladyship, Mr. Mutuku has asked for another 2 months, until the 30th of April 2020. That will have given them 10 months. And thereafter he has the audacity, shameless audacity, to say, we can then have a pre-trial 1 month later, then we can be all ready for July. If the defense agree, we can cooperate. And if we further cooperate, the case will proceed without adjournments. Ladyship, they will have had 10 months, and they will have given the defense less than 2 months, and they consider that fair play. It actually less than 2 months, about 3 weeks to prepare. I call that ridiculous, I call that presumptuous, I call that arrogant, I call that a reflection of impunity. This case is about, of course, the deceased, but certainly about the rights of victims, the rights of the accused. But what we have been treated to here is a complete circus, complete trampling of the rights of the accused in violation of Article 50, Sub-Article 2C. Your Ladyship, I have said this before. My learned friend now says, provided so many statements, totaling so many, then he goes on to say, 2 more statements will come that are witnesses under witness protection. 2 more under consideration by way of witness protection. Cybercrime, investigating officers, Murgor's experts, and service providers. 8 to 10 more statements, Your Ladyship. It is already a mistrial. It's already a travesty of justice, and may go down already as the most scandalous investigation and prosecution in this country. The Constitution requires that the investigation should have been completed before the accused, 1 and 2, were charged. The law permits for the occasional dimension or bit of evidence to be admitted after that, because of course the prosecution cannot anticipate everything. But what we have seen here, Your Ladyship, is a case where it now is clear. The 2 accused persons were charged on a whim, on a fancy by Mr. Mutuku and those who asked him to sign that charge sheet. Thereafter, what we have embarked on is a journey to find the evidence to justify the prosecution. It is a great shame on the criminal justice system. So, Your Ladyship, in short, and maybe there's one more that I mentioned here. The letter that is before the court that my learned friend referred to, dated 22nd of January, 2020. Your Ladyship, that letter suggests that the evidence that was collected by the scenes of crime officers in the month of September 2019 was only handed over to the government's chemist in January 2020, and therefore they require 2 months to investigate from that point. Ladyship, if this is how the case is being conducted, it means there is no intention of ever concluding the investigations. There is no intention of accepting there will be that it was a mistake, and perhaps it is time for us as the defense to reflect on applying for a mistrial. Your Ladyship, that letter speaks for itself. I conclude by saying, in a case such as this, based on the adversarial system, there should be equality of arms, as it were. Whatever time the prosecution takes is the time that the defense should be entitled to take. We have supplied letters to the court dated 8th November 2019 and dated 20th February 2020, all indicating that the defense were making serious requests. For example, access to the alleged scene of crime so that the forensic expert on the defense side can conduct certain tests, asking for phone records, asking for expert reports from their side so that the defense can exercise their right to take second opinions. I can only say from where I'm standing now, that if they take 10 months, the defense will take 10 months. So to dangle the July hearing dates as an incentive to us is a mirage. As of now, this case is collapsing even at this stage. As of now, I can tell the court on behalf of the first accused, we will not be ready on the July dates. Because as of now, we have had nothing from the prosecution to enable us even start preparing the defense. Ladyship, my final request is that the court guillotines the time for presenting evidence at today. I will accept the last bundle on behalf of the first accused. The second accused lawyer has already accepted this. end it here and now, perhaps then we might be ready in July. As of now, we are being treated to all sorts of shenanigans, all sorts of. We were told of other accused persons coming in at the last hearing, at the last mention. We see no mention of it. All this sensation, all this drama by the DCI, and when we come to court, there is nothing. I rest my case. Thank you. About the redacted statements, Your Leadership, I am reminded that through the course of these proceedings, we have been given at least two statements that were redacted. They want to redact them more, yet they have given some that are not redacted enough. How will that help them? Your Leadership, I think that is just an excuse to buy time. I am reminded also that the Witness Protection Program is physically housed in the office of the DPP. So time is not something that they can rely on. They walk across the corridor and they make those arrangements, they redact their statements, place such witnesses in protective custody, and allow us to carry on with the case. All these excuses will not help us. Thank you.
With the information, let me start.
What is that one? Finish what you can respond to both.
My lady, I must indicate that this is indeed an unfortunate and a sad afternoon. I was served with an incomplete bundle at around 1:30 p.m. At least 1 hour to the ruling that you have just delivered, my lady.